Yes.
Okay. Before lunch, I sort of outlined what are points on construction in relation to the interaction of Section 684, 7A, Regulations 185 and 188 are. I'd now like to develop in somewhat more detail what those points are. The first being that the discretion in Section 684, 7A only impacts on the position of the payer, so the end user, and not on the position of the payee, the claimants. And we say this follows from both the language of subsection 7A and also from the language of Regulations 185 and 188. Before developing that, I think it'd be helpful, or certainly helpful from my point of view, to just go through the principles of construction which we're relying on, which are, I appreciate, well known, and the court will be well familiar with them. But there's been a recent and helpful summary by the Supreme Court in the case of on the application of O and the Secretary State for the Home Department, which is in the bundle of authorities tab 61, which will be volume 5. And the relevant paragraph is at paragraph 29 on page 1859 of the bundle. We see the courts in conducting statute interpretation are seeking the meaning of the words which Parliament used. More recently, sort of referring to Lord Reid, then more recently Lord Nichols stated statute interpretation is an exercise which requires the court to identify the meaning borne by the words in question in the particular context. Then words and passages in a statute derive their meaning from the context. A phrase or passage must be read in the context of this section as a whole and the wider context of a relevant group of sections. Other provisions in a statute and the statute as a whole may provide the relevant context. They are the words which Parliament has chosen to enact as an expression of the purpose of the legislation and are therefore the primary source with which meaning is ascertained. There is an important constitutional reason for having regard primarily to the statutory context, as Lord Nichols explained in Spath Home. Citizens, with the assistance of their advisers, are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. They should be able to rely on what they read in an Act of Parliament. External aids to interpretation, therefore, must play a secondary role. Explanatory notes prepared under the authority of Parliament may cast light on the meaning of a particular statutory provision. Other sources, such as Law Commission reports, reports by Royal Commissions and advisory committees, and government white papers may disclose the background to a statute and assist the court to identify not only the mischief which it addresses, but also the purposes of the legislation, thereby assisting a purposive approach of a particular statutory provision. The context disclosed by such materials is relevant to assist the court to ascertain the meaning of the statute, whether or not there is ambiguity and uncertainty, and indeed may reveal ambiguity or uncertainty. But none of these external aids displays the meanings conveyed by the words of the statute that, after consideration of that context, are clear and unambiguous and which do not produce absurdity. I think that picks up a point my Lord Justice Henderson made earlier about the use of explanatory notes.
Yes.
Paragraph 31, statutory interpretation involves an objective assessment of the meaning which a reasonable legislature as a body would be seeking to convey in using the statutory words which have been considered. And then he sets out what Lord Nichols said in terms of parliamentary intention being objective intention in Spath Home. And then finally looking at paragraph 33, before turning to consider the two cases in which the appellants principally relied in their submissions, it is necessary to observe that, as the appellants accepted in their submission, this appeal is not concerned with common law rights which have been recognised as fundamental or constitutional, nor is it asserted that any convention rights under the Human Rights Act 1998 are engaged. In a series of cases between the early 1980s and the early 2000s, the courts repeatedly recognised the right of unimpeded access to the courts as a fundamental or constitutional common law right, and then cites various of those cases. And then sets out the statement of the principle of legality from Lord Hoffman in the Sims case. Parliamentary sovereignty means that Parliament can, if it chooses, legislate contrary to fundamental principles of human rights. The constraints upon its exercise by Parliament are ultimately political, not legal, but the principle of legality means that Parliament must squarely confront what it is doing and accept the political cost. Fundamental rights cannot be overridden by general or ambiguous words. This is because there is too great a risk that the full implications of their unqualified meaning may have passed unnoticed in the democratic process. In the absence of express language or necessary implication to the contrary, the courts therefore presume that even the most general words were intended to be subject to the basic rights of the individual. And then he says, because, as is not disputed, we are not concerned in this appeal with fundamental common law rights, the special rule of construction, which is embodied in the principle of legality, has no application. I should say, we do say that that special rule of construction applies here.
On the footing that you're taxed by, on what footing, sorry?
On the footing that it is a constitutional principle that, well, on the footing that being taxed, being subject to a charge, if I put it in those neutral terms, does engage a fundamental principle, a fundamental constitutional principle. And here, what is being said is that a general discretion allows Hmrc to put a liability, or to put an obligation to pay on the claimants.
That's just a collection mechanism. It's nothing to do with the underlying liability. And this brings one back to the continuous ambiguity, which seems to permeate an awful lot of your submission.
I apologize, my lord. I am trying to keep the language clear,
Yeah.
and I appreciate that liability is a word which is capable of covering.
Okay, so what is the fundamental right to have tax collected in one way rather than another in
No.
respect of one underlying liability?
I think, my lord, and this goes back to the Bill of Rights, that the right to require a citizen to pay money is to be enacted by Parliament.
But that's liability. That's liability to tax. That, I agree, is a fundamental.
My lady, with respect, the claimants are being required to pay money, which they would not be required to pay but for the discretion. And we say it's the obligation to pay money which engages that constitutional principle. Because from the point of view of the claimants, the niceties of the tax code and the distinction between liability and collection aren't something which concerns them. What concerns them is that they have to reach into their pocket. They're being required by the state to reach into their pocket and pay money. And it's that requirement, that obligation, which I submit engages the...
Well, they're claiming the right to keep money which should have been paid.
With respect, no, my lord. We looked at Regulation 185 and Regulation 188, and it's entirely clear from those provisions that they were not obliged to pay anything right up until the point when Hmrc exercised their discretion and query whether that had the effect. So,
well, forgive me, there is a liability and somebody should have paid that tax.
there is an obligation to pay tax. The person who should have paid that was the end user. That's what the legislation provides.
So the claimants undoubtedly have money which should have been paid to Hmrc.
Well, I don't think that's actually the way the legislation operates. They have money. The consequence of their having that money is that there was an obligation for someone to make a payment to Hmrc.
But that payment would have been preceded by a deduction.
Well,
From the gross amount that was paid to the claimants, there would have been deducted an amount of PAYE tax, and that would have been collected from the end user in the ordinary run of things.
my lady, I don't think that's correct, bearing in mind Section 710.
Isn't it?
So when a deduction cannot be made...
Yes, if a deduction couldn't be made, then there are other things that follow. But in the ordinary run of things, the expectation would have been that the money would have been paid to the by the end user, having deducted the fee for the contractors would have been paid, having deducted the PAYE, which would then have been accounted for to the revenue. Isn't that right?
Well, yeah, that's one way in which it could have operated, certainly. But in terms of these particular arrangements and the way in which they were operating, the payment into the trust, what that did under Section 710 was created an obligation on the end user to account to Hmrc for an amount of tax.
Yes.
And the legislation is quite clear, and that makes a distinction between accounting for tax and deducting tax, because you can't go along and say, well, there was nothing we could make a deduction from, therefore we're not obliged to pay anything. So the legislation says, well, it doesn't matter if you couldn't make a deduction, you have to account for it.
Well, for my part, I quite understand, and we're all here to hear your technical arguments as to why the claimants are not obliged to pay their liability for tax. But whether that can be classified as a matter of their fundamental common law rights, I rather doubt.
My Lord, I will go on to look at sort of the way it's been put in the case law, but certainly the fact is that there is not an obligation to pay these amounts. There was not an obligation on the...
I think that's what I just said. I think we're
Yes.
listening to your technical arguments as to why you shouldn't be obliged to pay. What you accept was your liability.
Yeah. Well,
And what I repeat what I said is that while I understand that you're entitled to mount those arguments, I don't find much force in the suggestion that this is a matter of your fundamental common law rights.
right, well, my Lord, I think sort of I take your point that you see it as a technical issue. I'd suggest that people in the claimant's position, it's rather a practical one, because on day one, they do not have to reach into their pocket and pay money to the revenue. On day two, after they receive the letter, they do have to reach into their pocket and pay money to the revenue.
But this is in respect of their own liability to tax on their own employment income.
Well,
So, I mean, how one gets a constitutional principle out of that when all they're being asked to do is pay tax on their own earnings?
well, because they weren't being asked to pay that tax beforehand, and in fact, they were getting
Because
credit.
they'd arranged their affairs in a tax avoidance scheme.
Well, I don't think. I think the tax avoidance scheme is one side of it, and obviously, everyone thought that nobody had the obligation to account for PAYE under the avoidance scheme.
But it didn't work.
But it didn't work. And then the question is, well, the avoidance scheme didn't work. Who does the obligation to pay the amount fall on? And in terms of the PAYE code, the House of Lords or the Supreme Court looked at that in Rangers, and they said, well, actually, PAYE applies to these payments as well. That was a case in which it was the employer, and it was very clear that the employer had the obligation to account for PAYE, and it didn't matter that in terms of what went into the trust, there had been no deduction.
And here, if these had been onshore employers, the same would have followed. There wouldn't have been an argument.
Yes, if these had been onshore employed, but there would have been still have been the right to the credit. So if these had been onshore employers, the primary obligation to pay the tax would have been with the onshore employer.
Yes, in the normal way, that would have been discharged, so there would have been no problem. You know, the machinery which 99% of the employees in this country are used to having operated would have operated.
Yes, but what wouldn't have happened would have been that those onshore employers would have been able to take the money back out of the trust, absent specific provisions in the trust, because those earnings have already been paid.
But you accept, though, that there is mechanism here where exactly this transfer could have taken place.
Yes.
So you're not suggesting that there is you're not objecting to those on a human rights or fundamental common law rights basis. So the only question is whether or not, as a matter of interpretation of the regulations in their statutory framework, the same result is being achieved by a different route.
Well, the point about the principle of legality is that Parliament can infringe on constitutional rights, but it needs to do so by clear words. And I think there's no doubt that we have clear words in the legislation in terms of Item 4A, Section 684, in terms of Regulation 72, Regulation 72F, Regulation 81. Those are clear words granting the authority to transfer the liability within prescribed circumstances.
So you suggest that the provisions that you took us to, 185, 188, 81, those also infringe upon the claimant's fundamental common law rights?
No, my lord.
I thought you just said that the reason why
Sorry.
those were not objections was because they were clear.
The provisions allowing Hmrc to transfer liability, that is a discretion on the part of Hmrc to transfer liability, but that has a clear statutory basis, so there can be no objection to it. The point in relation to 684, subsection 7a, is that it said that this is a discretion in very general terms, which allows Hmrc to transfer, obligation to pay, which requires the claimants to pay an amount which they previously didn't have to pay, and to pay that to the state.
So is it that, in relation to the other regulations that my lord just put to you, Parliament, but it's secondary legislation anyway, but Parliament has confronted the potential for some interference with fundamental rights, whereas you say 7a is in such wide and general terms that Parliament can't have confronted it.
That's my point, absolutely, my lady, yes.
Yeah.
Okay.
And so, sorry, just to sort of pick up a slight point there, it isn't just in the regulations that Parliament has confronted it, it's also in item 4a, which specifically empowers Hmrc to put those into the regulations.
Item 4a.
And does it make a difference that our regulation 7a is in primary legislation, indeed in the very same section as the paragraph 4a, which you accept is acceptably worded?
Well, certainly we say it makes a difference whenever one looks at the general and specific, that point in relation to it. But I think it also makes a difference because, going back to what Lord Hodge was saying, is that it's important to look at the statutory context. And the statutory context of 7a is that it's sitting there right next to a provision which expressly deals with this. And so Parliament has engaged with the issue and has said, this is the way in which we're going to deal with it. And so my submission is that the fact that that is there is part of the wider context, and that suggests that the provision in paragraph 7a wasn't intended to achieve the same outcome. It wasn't intended to render those provisions redundant.
Well, on no view does it render them redundant. It does just provide an opportunity to switch them off in suitable cases.
Well,
a very different matter, surely.
Well, I think with respect, I'd say it does render them redundant, and for this reason, that Regulation 72 and Regulation 81, as we've seen, have limits, they have safeguards. But why would Hmrc need to be bothered with those safeguards if they can achieve the same result under subsection 7a? Because they can say anything which you can do under Regulation 72, the directions regulations, if I call them that, you can do under subsection 7a.
Only if it's a suitable case for the exercise of that particular power. And I mean, there's lots of law about the exercise of powers, and whether we term this a power or discretion may not matter much. But either way, it's not a carte blanche to do anything you like. On the contrary, the officer of the Inland Revenue has to form such and such a view.
I think he has to consider it's necessary or appropriate.
Yes.
And I think the whole point about the limitations in 72 and the other provisions is that they are situations where it's necessary or appropriate. So why bother having those regulations if necessary or appropriate is capable of covering them? And clearly it must be, because why would Parliament have legislated those particular provisions if they didn't come within it being necessary or appropriate to transfer liability? Well, I think it's also worth bearing in mind what subsection 7a actually says. Because although it's been used to place an obligation on the employee, it makes no reference to the employee at all. So on page 236, nothing in the PAYE regulations may be read as requiring the payer to comply with the regulations. And so that's all about the payer. And our main point on this is that relieving the payer of an obligation does not, in terms, transfer that obligation to the payee. And that's also consistent with Regulation 185 and 188. Because what they talk about is an amount which the employer was liable to deduct. Or was liable to account for. Now, it is absolutely the case that the end users, each end user was liable to account for tax, notwithstanding that they are no longer liable to account for tax. And in terms of the context again, it's also relevant that this discretion is said to impose an obligation to pay an amount on a claimant. But Hmrc are saying you've got no right to address that in the first-tier tax tribunal. There's nothing in the legislation which suggests an obligation to notify the taxpayer. There's no limit of time. So, if we consider the position of, it's a different position, but a taxpayer who doesn't agree that tax is due, but doesn't care because he has the credit, what happens when Hmrc exercise the discretion there? He's fixed with a liability, but he's got simply no right to challenge it. So, in the context of the machinery, which is very much about allowing people to assert their rights, the denial of that right, the fact that it's not built in, it's not provided for, strongly suggests and strongly supports, I submit, that the exercise of the discretion doesn't have the secondary consequence of impacting upon the employee.
Well, when you say there's no right to challenge it, you mean there's no right to challenge it via a statutory appeal? I mean, of course you can challenge it as you are today.
Well, yes, but I think where it's slightly different is, and then the bit where you wouldn't have the right to challenge it, is if the amount of tax, which the tax liability, as it were, hasn't been challenged in time, but the employee doesn't care because he has his tax credit, so it makes no difference. You'd have no right to challenge that because you're out of time in terms of the exclusive machinery, and the exercise of the discretion doesn't impact upon that tax liability.
I think the revenue accept that, I mean, if the revenue are out of time in any event, an exercise of the discretion can't get round that problem for them. I mean, they're only in time here because they issued assessments, albeit under various discovery assessments, which are no longer challenged in this court, or other permission to appeal having been refused on that part of the case.
Well, it's certainly possible to have a self-assessment which includes amounts of what are treated as employment income, which the person who's making the self-assessment has no interest in challenging because they have the credit. And so if you had that sort of self-assessment, then it wouldn't matter that the Hmrc are out of time because actually it's been assessed anyway. And what you're then impacting on is, well, the credit's been taken away and the employee doesn't have a chance to challenge the assessment. He wouldn't have self-assessed in that way if he'd known this. But frankly, one of the impacts of having the credit is, why would you bother? Because practically, it's not something which is going to impact on you. And that's why I say that appeal machinery is quite relevant here. And the other part of the context is that the power is conferred on Hmrc, which is a body whose powers are historically very limited in scope. And a recent example of that is in the bundle at Authority 60, which I think should be Volume 4, the 5.
Well, it depends how far back you're going, doesn't it? I mean, what you mean by historically limited. And we have lots of statutes, so one might think this is an example of one where Hmrc are given very wide powers to make regulations in respect of PAYE, which will actually prevail over anything else in the tax code.
Well, certainly, I completely accept that that's a possible construction. But the point I'm making here is that if you have a body which has very limited and tightly confined powers.
Well, is that right? I mean, they have care and management of the entire tax system.
Well, they do have care.
In my book.
Well, I think this is why I want to take you to this case as to how that care and management power is construed.
Yes. Is this clamp? Is that what?
That's right. Yes.
What page are we going to?
Page 1843. Sorry, tab 60. So at paragraph 41 and 42, we have reference to the limits on the managerial discretion as addressed in the Wilkinson case. And then at paragraph 44, they cite from a recent decision of Lord Justice Green, where he says, the House of Lords in Wilkinson made clear that the commissioners had a broad discretion as to the use of the powers of management, but that this did not extend to untaxing the taxable by an extra statutory concession, which said that it follows that once the commissioners were of the settled view that the airside taxes should have been taxed, then there was no residual power to untax. And then we see the conclusion of paragraph 47. In my judgment, at least, in a case where Hmrc have formed a settled view that tax is payable under the legislation, and that view cannot be seen to be irrational or formed for improper purposes, they do not have that power, i.e. the power to change their mind. I consider that this is in keeping with paragraph 90 of Heathrow Airport, that's the Lord Justice Green decision. I also consider that it's in keeping with the proper limits. I also consider that it's in keeping with the proper limits of the collection and management discretion in this area. That discretion is, as Lord Hoffman put it in Wilkinson in the passage I've quoted, one which enables Hmrc to formulate policy at the interstices of tax legislation and to deal with minor or transitory anomalies. It is not one which allows them to untax matters which they consider are unequivocally taxed on the basis that another view of the legislation is arguable, a situation which, of course, might arise in relation to numerous taxation provisions.
That's about imposing primary liability, not about collection.
Well, I'd submit it's probably in relation to both, that sort of under the collection and management powers, Hmrc certainly couldn't decide that actually we're not going to go after the employer, we're going to collect off somebody else.
Exactly.
But that's in relation to collection, and their powers of management wouldn't extend to deciding who to collect money off. So under the collection, their powers of management, the general powers, this is not something which Hmrc would be able to do.
Without repeating myself, what can possibly be wrong about using a power of collection in order to collect tax from the very person whose liability it is?
Because it's not their obligation to pay, and it's sort of, I think...
Well, it's their liability, and they've got to bear the economic burden one way or another by deduction of tax, or else by direct assessment in certain circumstances.
My Lord, I think with respect to your comments about the use of the word liability and how it can be unhelpful apply as equally to the stage 1 point as they do to the stage 2 point. And so sort of one's talking about, well, they have a liability, well then you'd think that it would automatically follow from that, well, if you've got a liability, why aren't you paying? And the reason is that this is not a liability which causes somebody to have to pay anything.
Well, they are paying. I'm sorry. You pay.
By deduction.
The salary which is paid to me, it's out of that salary tax is paid. It's just that it's deducted by my employer, but I am paying it.
Indeed, but if your employer decided not to deduct it,
Yes.
your employer would still have an obligation to pay an amount to Hmrc, and that might be a grossed up amount. And that they would have that obligation regardless. And what couldn't happen is Hmrc coming along going, actually, your employer got it wrong last week. They give you the full amount and they should have deducted it. We want you to pay that amount. Because that's not the way the legislation operates. The way the legislation operates is Hmrc have to go off after the employer and get the money off them. Now, it might be that the employer can come...
The employer asks you for the money back.
Well, absolutely. And if Hmrc had gone after the end users, and then the end users could have come after the employees in this case.
But what the whole system isn't designed to do is to leave the employee with a windfall where they have the tax in their pocket but are not obliged to pay it. That's not the aim of the system, purposively or technically.
Well, I think actually the aim of the system is to make sure that tax is paid. And the way it achieves that is by putting the obligation to pay that tax on the employer or here the end user.
That's what showing us there are situations where that happens, and the result is that the employee then has to pay more tax.
Yes.
Because it hasn't worked, and what's happened is that he's taxed on the windfall.
Yes, and it may be that the employer or the end user has a restitutionary claim against the employee, but in terms of the system, it's not concerned to see that actually the person who bears the economic burden at the end of the day is the employee. What it's concerned to do is to make sure that an amount of tax is paid to the exchequer. And the way it does that is by going after the employer, going after the end user, and leaving it to the employer or end user to sort out, as between itself and its employees, how that should be dealt with. Now, if the employer decides not to do anything, you may have a Section 2.2 situation. If you don't do anything within 90 days, you definitely will. But in terms of what the legislation is trying to achieve, I think one needs to be careful not to read into it sort of purposes which aren't there. What it's there to do is to collect money. And the way in which it does that is by fixing on the employer, and then it leaves it to private law for the employer to deal with the obligations as between itself and the employee in most cases. And what we say is, if the employer hasn't paid, and if Hmrc are out of time to assess the employer, then just like in any other case where if Hmrc are out of time to assess, then tax does go unpaid. And obviously, it's not a purpose of the legislation that tax should go unpaid, but it's very much a feature of the legislation that it is accepted that in some cases, tax will go unpaid because you haven't used the right assessment machinery. And that's the issue here.
But what would be surprising in this legislation and the scheme would be if there was a power to not collect from the employer, which had the effect of meaning that the tax wasn't collected at all. And that's, as I understand it, what you're suggesting is...
No, there's a clear part not collect from the employer in Regulation 81, which is the one which would have been available here. So the employer hasn't paid, Hmrc can decide, we're not going to collect from the employer, we're going to transfer liability to the employee.
No, but as I said, your construction, your suggestion in relation to 7A is that it only impacts on the payer and not on the employee.
Well, my lord, what I submit the mistake you're making is that thinking that 7A is about transferring liability to the employee at all. Because I submit, if it was intended to do that, it would say that in fairly clear words. And if it was intended to do that, why then do we have item 4A? What 7A is intended to do, and this is why I say the context is relevant, is to relieve the payer of an obligation where it would be inappropriate for the payer to comply with that. What it's not there to do, and sort of one can see it on its face, it's not there to transfer a liability to the employee. It makes no reference to transferring a liability to the employee. That's something which, my learned friend says, follows automatically.
Well, I won't pick you up on the word liability again, but that does mean that what you're suggesting is that 7A has is there to relieve the employer or end user of the obligation to pay, but without there being any corresponding obligation on the employee to pay.
Well,
it seems an odd outcome.
Well, it does seem.
Sorry, yeah, finish my question. Why would that be an interpretation we should put on the legislation?
Because it was never, the section was never there to do that. Now, I say it's important to have regard to the context of the legislation as a whole. Now, that context includes a power to do exactly what the revenue want, and that's item 4A. 7A talks about relieving the payer of an obligation to comply with any of the PAYE regulations. Now, the one we're focusing on is the obligation to pay, but there are other obligations in there which a payer could be relieved of. So I think it's a very, very general power, and for understandable reasons, we're considering it in the context of the particular exercise which we're looking at here. But it's a general power which can achieve lots of different things. And by saying it can't do the specific thing which we're talking about here, we're not saying the legislation has no meaning, it can't achieve anything. What we're saying is it just can't do this particular thing, it just can't transfer a liability to an employee.
But what's the point? My Lord's point is, what's the point of a provision that just relieves without identifying some means of collecting the tax from the person who has the liability?
Well, that presupposes sort of that it's intended to relieve, but let's assume that it was there to relieve. I say it's there to deal with sort of anomalous situations where there's a liability which doesn't really help. And the example I gave was...
Well, I understand it's there to deal with anomalous situations or unusual situations, but isn't the necessary consequence of that one would have expected it also then to have a corresponding obligation on the person who's liable for the tax to pay the tax?
I don't...
Otherwise, what's the point?
Well, because there may be situations, and the example being the student, where actually relieving the payer of the obligation to pay the tax has no net effect, because actually all that's going to happen is the student pays tax under PAYE and claims it back. So you relieve the payer of the obligation to do it. You make everything much more administratively convenient for everybody. So in that circumstance, it clearly is appropriate. But you might say, well, if the effect is that it doesn't transfer liability to pay the tax, transfer the liability to pay, or the obligation to pay, then it's not appropriate to exercise the power. Because in that case, all you're doing is creating a hole in the exchequer. And in that case, what you should do is use the power which works the way it's intended to, and which the machinery fits neatly with, and the legislation fits neatly with, and the language fits neatly with. Those are the express powers. That's why, sort of, in the context of Hmrc having limited management powers, it is unusual that you're seeing a discretion to transfer such quite large numbers, or quite large amounts of liability of obligation to pay, sorry, from one person to another. And I say that's unusual, and I absolutely take the point that, well, it might be unusual, but that might be what the legislation does. But what I say about it being unusual is that it suggests that maybe the legislation wasn't intended to do that. Well, it's just in terms of fundamental rights. The relevant principle is set out in the Majesty case, which is at tab 6 of the bundle, volume 1.
That is about primary liability. That's about imposing liability for tax. We all understand that principle, I think. Well, the issue is that it doesn't arise in this case.
Well, Yes, I think that's quite the point, lady. That's what we rely on. I've given you the references in my skeleton argument.
That was a notorious example of what many people would term revenue overkill, in relation to actually not this part of the case, but the TOAA.
Yes.
That was the background to it. Of course, the revenue don't have a discretion to impose liability at their whim between different taxpayers.
Well, yes, but I think taking a step back, we say that it's not hugely different. What's happening here is you have the revenue saying, we don't think it's fair that you should have to pay. We think it's fair that you should have to pay. So we're going to exercise a discretion to transfer.
Your client has a fundamental right not to pay tax on his own earnings.
No, my client has a fundamental right I think where the fundamental rights come in is that...
Just tell us what you were just about to answer. My client has the fundamental right
to pay tax in accordance with the clear legislative words. So we have the principle that tax should only be imposed by clear words.
And you...
Okay. And I get that we can go back and forth on the difference between tax and obligation to pay.
Yeah.
My submission comes down to that whenever you're looking at the constitutional right, it's a practical right that doesn't turn on the niceties of the distinction between assessment and liability. And to the extent that that principle is engaged, then we don't have the clear words which would be necessary. Although we do, I accept, elsewhere. So those are the sort of general points on construction. Looking now at two sort of more particular ones. Firstly, that the section operates prospectively only. And there are two aspects to that. One, the language of the legislation. And two, the presumption against retrospectivity. On the second, the case which we rely on is at tab 8 of the authorities bundle. It's the Privy Council case, Ubon Chu. And the part of the judgment I'd like to refer you to is on page 145.
Just before we go there, the principle that you're relying on is that you shouldn't be taxed retrospectively.
Well, no, statutes shouldn't be construed to apply retrospectively.
Okay.
Sorry, is this the passage on page 145?
Yes. And over the page on 146, the two passages which are sidelined.
Yeah.
And then it's sort of clearly set out on page 150. Their lordships consider that the proper approach to the construction of the Act of 1974 is not to decide what label to apply to it, procedural or otherwise, but to see whether the statute, if applied retrospectively to a particular type of case, would impair existing rights and obligations. And then we see at D on that page. In their lordships' view, an accrued right to plead a time bar, which is acquired after a lapse of statutory period, is in every sense a right which, even though it arises under an act which is procedural, is a right which is not to be taken away by conferring on the statute a retrospective operation unless such as construction is unavoidable. And here, there is a right, the right under Regulation 185 or 188, to treat tax as having been paid. And what has been said is that that right has been removed with retrospective effect. So we say that engages the principle.
So unless it's that construction is unavoidable,
Yes.
we shouldn't adopt it.
Yes, madam. And that's a point which has been accepted in relation to this power in two cases. Firstly, in the Lancashire case, in the First Tier Tribunal. Now, I should say, as I understand it, that's a case which is under appeal. It's obviously First Tier Tribunal. But what I do say is the points are well made and are correct. That's at tab 41 of the bundle. The relevant analysis is at paragraph 245. And 245 to 249 deals with, if I call it the linguistic point. So if it just read 246, in my view, it is
Sorry, I'm not there. 245, paragraph 245.
Sorry, paragraph 2.
Okay.
I apologize, my lady. Page 1246.
124.
Oh, sorry, 1276. Sorry, my eyes are.
1276. Okay, just wait. I'm not there yet. There must be a better way of getting there. So you want us to read 245?
Well, yes. 245 to 249. Well, 245 really just sets out the legislation, but 245 to 249 deals with the fact that linguistically,
Yeah.
it's prospective only. I think one point to note about if the legislation is prospective only, or objections in terms of regulations 185 and 188 fall away, because 185 and 188 talk about amount which the employer, the end user, was liable to pay, deduct or was liable to account for. But if you've removed that obligation before it arises, it's not the case that they were ever liable to deduct or ever liable to account for anything. And so that fits. But in terms of the points being made there as to the language talking about a live obligation and to comply with that live obligation, we'd adopt that as a correct statement of The next section goes on to discuss whether the legislation, if it could operate respectively, could retrospectively impact on the taxpayers' rights. And the points made there at paragraph 254, that it doesn't follow that just because the payer can be relieved retrospectively, that applies to the payee.
Why is the effect to generate wholly unexpected tax liabilities for taxpayers who have accounted for tax according to the applicable law? There's no suggestion here that the claimants or Mr. Hoey have accounted for tax in relation to.
I think what that's talking about is people who've accounted for tax in accordance with applicable law, people who've taken the benefit of Regulation 185 and 188, which say that when you're accounting for tax, and I think that's the sense I'm using, you treat as paid tax which an employer was required to deduct or required to account for.
Well, that's not accounting for tax. That's being treated as having accounted for tax.
Well, I think if you're treated as having, let's say the tax liability is 50, and if you're treated as having paid 25 and you pay 25, you have accounted for tax correctly because your requirement to pay is only 25.
And that's what's meant there, is it?
I believe that's what's meant there. But again, we say that's correct. And as we see, it was the approach which was also adopted by the upper tribunal in this case.
I'm afraid I've forgotten. Did the upper tribunal refer to and rely on, or at least obtain persuasive support for their views from Lancashire?
Yeah, they certainly referred to these paragraphs of Lancashire.
Yeah, yeah.
If I just take you to what the upper tribunal said now. This is tab 11 of the core bundle. Starts on page 177.
Paragraph?
Well, I think if we start at paragraph 109 on page 205, just to note there that as far as the upper tribunal was concerned, and certainly as far as Mr. Hoey is concerned, there was full argument heard on this point. It's a point which Hmrc making a skeleton argument that it wasn't, but I don't know where that view has come from, but certainly the upper tribunal considered that there was full argument.
It was obiter because they held they didn't have jurisdiction to deal with the point.
But no, I don't dispute that it was obiter. I dispute that there was not full argument.
Obiter but fully argument.
Yes. But I suspect nothing turns on it because certainly before this court, there is full argument. And then it's paragraph 118 and 119, starting on page 207. The Hmrc's counter-argument emphasises the breadth of the 7A discretion. It refers to relieving the payer's compliance with any regulation, therefore it can relieve the payer of the obligation to deduct tax, deduct in the first place, thus cutting off Regulation 185 and 188 at the pass, as it were. The argument has prompted us to reflect on the precise scope of the 7A discretion as it applies to a case such as this, where the direction was made after the point in time when the obligation to make the deduction had already arisen. We can well see that if the obligation to deduct were relieved before the liability to deduct has occurred, Regulation 185 and 188, which envisage that there was an obligation to deduct tax, clearly have nothing to bite on. And that was the point which I just made. No PAYE credit under those regulations can then arise. But if the 7A disapplication is made after the deduction has been made, Regulation 185 and 188 and the credit they give rise to will already have crystallised. That then leads to the question of whether the 7A disapplication must also be regarded as undoing that credit, or in other words, rewriting the state of affairs that existed, such that Regulation 185 and 188 are not to be regarded as ever having operated. We consider that 7A cannot be construed in that way for the following reasons. The plain reading of the language is that it has prospective effect. And that's where they refer to Lancashire.
Thank you. Yeah.
So construed, the direction results in adverse retrospective effects. Those adverse effects do not, of course, fall on the subject of the direction. Where the deduction obligation is removed after the event, the employer or person treated as employer for PAYE purposes will be relieved. It is the employee who suffers the removal of the deduction obligation after it has arisen. Tax that under the law as it stood at the time ought to have been deducted was not. Tax which therefore the employee was not expecting to be liable to pay for becomes liable. That is not through a direction made on the employee with notice and satisfying certain preconditions. If Hmrc are right, it is the result of a direction to the person who in the first instance had been liable to pay the tax over, i.e. the employer. This is not, of course, a point about liability at the earning stage being imposed retrospectively. Rather, it concerns liability at the who is liable giving the PAYE system to pay the tax stage being altered after the liability accrued. But the broader point of the objection is nevertheless that a person's liability position under the law as it stood is later altered adversely. The statutory scheme makes no provision for notice and imposes no conditions, in contrast to the direction regulations. Those show that where legislation alters the default PAYE framework, it does so on a condition basis and with protections. The employee direction provisions, by their nature and drafting, operate after the event. They provide for the preconditions and appeals. While they do not necessarily support the view that a 7A direction cannot have prospective effect, because 7A operates to remove deduction liability and therefore does not require an expectation to be made to the PAYE credit regulations, they show that when the who should pay the tax position is altered after payment, conditions and protections are put in place around that. And if 7A were to have this retrospective effect, one would expect clear words. In fact, the statutory language is consistent with prospective effect. And even if 7A could apply retrospectively, one would expect to see that Regulation 185 and Regulation 188 would explain that they do not apply where the obligation to deduct has subsequently been relieved by the exercise of the 7A discretion. And that's picking up the point that Regulations 185 and 188 do expressly deal with the directions regulations, which itself, we say, is an indication that it's only in those circumstances that the rights under that section are impacted. So again, we say that is correct and we rely on that and say that the upper tribunal, it may have been obiter, but it was correct. And this discretion can only operate prospectively. Which brings me on then to my third point of construction, that the very general words of subsection 7a cannot operate as an alternative to the very express and specific provisions of regulations 72, 72F, and 81. And I take the point that they are made in regulations, but as we've seen, subsection 7 says that the income tax acts are to have effect subject to the regulations. So they give the regulations priority. And secondly, the provision under which they're enacted is in the same section, item 4a. Right, well, sorry, subsection 2 and item 4a, which expressly anticipates that power. And we say those are specific provisions which do precisely what it is that Hmrc were seeking to do. And that is transfer liability to an employee. And that's very clear from Mr. McFarlane's evidence that he was exercising the power to fix the employees with liability, with obligation to pay. And in many cases, they didn't even know who the end user they were relieving of an obligation was. And so, go back to a point I made earlier. On Hmrc's case, the discretion allows them to do precisely what those direction powers enable them to do. And what that does is that it renders limits on those specific powers redundant and means that a protection which a taxpayer may have thought they had, that this transfer of obligation can only be made subject to certain express requirements, has been removed. In my skeleton argument, I referred to Benyon and the Baby Products Association case. My other friend has referred to two other cases. I think perhaps if I look at what Benyon says, just to give a general overview, and then look at the two cases my other friend referred to, it's found in the final bundle of the authorities at tab 73, page 2207. So we see it's a principle of construction that in the absence of any contrary intention, the general gives way to the specific, where the literal meaning of a general enactment covers a situation for which specific provision is made by some other enactment within the act or instrument. It is presumed that the situation was intended to be dealt with by the specific provision. And then he refers to Sir John Romilly in Pretty and Solly. And just at the top of page 2, the principle does not apply where instead of specific provision and a more general provision, there are simply provisions with overlapping aims and overlapping applications. And just to note on page 3, under general power, he sets out what Lord Bingham said in the Baby Products case. Power conferred in very general terms plainly cannot be relied on to defeat the intention of clear and specific statutory provisions. Now, that was subject to some critical analysis by Mr. Justice Ouseley in the British Bankers Association case, which my learned friend relies on. That's at tab 22 of the authorities. This case was a challenge to a policy statement by the FSA in response to payment protection insurance mis-selling. And the third argument which had been raised was that the FSA used their policy statement to require firms to compensate customers when it should have followed a specific statutory procedure. And the analysis on that ground starts at paragraph 189 on page 574.
Sorry, which tab are we in? My fault.
Sorry, tab 22, which
Thank you.
I think should be the second file of authority.
Sorry, did you say tab 22?
Tab 22, yes.
That's FII in my volume.
It should be perhaps the tab after that.
China, is that the one?
No.
No? Going completely around the bend. Authorities. So what's the name of the case again?
The case is the British Bankers Association and the Financial Services Authority, or the Crown on the application of the British Bankers Association.
Oh.
Well, perhaps at page 530, it might be the tab which has gone awry.
Mine's at page 580 something.
Oh. For some reason, maybe my tab 22 has been put in the wrong place. And indeed. Anyway, sorry, I'm with you now. Yes.
And do you want us to go to 574?
Well, just to note, on 574 is when the analysis of this ground starts. The bit which I'd like to take the court to starts on page 580.
580. Which paragraph?
So paragraph 212, we see Mr. Fordham cited the Beauty Products Association case, and then at 213, we see the citation from Lord Bingham in that case. And then the paragraph which I'd like to go to, paragraph 215. That principle was not at issue. Mr. Sprindle submitted that it was a clear and obvious case, but wholly distinguishable on its facts from the present. The local authority had sought to achieve the same end result as that which the statute provided for, but by an informal route. But that is simply wrong. The actions of the authority did not include making the supply a criminal offence, which is what the statutory scheme would have achieved. I confess to finding the application of the principle surprising, at least without very specific discussion of the differences between the effect of the scheme and the effect of the informal approach in that respect, and the reason for the procedural safeguards. A public announcement of a request that supplies of the products be suspended, which had no enforceable legal consequence, was held beyond the power of a public body because of the existence of a procedure whereby a suspension notice could be issued, breach of which had criminal consequences. The procedure actually adopted afforded no specific procedural protection for the suppliers, but breach of it also had no criminal consequences for them. So what he's saying was, I'm not sure about the analysis in the Beauty Products case, although I think, to be fair, in that case, the way in which the council had gone about it had pretty disastrous financial consequences for the companies involved. Mr. Fordham referred me to two other authorities, Credit Suisse and Waltham Forest London Borough Council, also concerned the scope of Section 111 of the Local Government Act 1972. Parliament had made detailed provision in a number of acts for the discharge of the housing duties on local authorities. These detailed provisions did not contain a power to give a guarantee in connection with a bank loan to a company which the local authority had formed to assist in the acquisition and development of housing for its statutory housing functions. And Lord Justice Neil said that, although the purpose behind what the Council did was laudable, where Parliament has made detailed provisions as to how certain statutory functions are to be carried out, there is no scope for implying the existence of additional powers which lie wholly outside the statutory code. Section 1113 makes it clear that the power to enter into a financial obligation is subject to any statutory controls which may be imposed. And then we see Lord Justice Peter Gibson agreeing. And then the other case was the R&J case, which held that it was an abusive process to prosecute unlawful sexual intercourse with a girl aged between 13 and 15 as a charge of indecent assault, so as to circumvent the one-year time limit, which by statute applied to the former but not the latter offence. And then at the end of the paragraph, they set out what Lord Rogers said on that. Section 14 must be construed and applied in a way which respects and does not defeat that intention. this is enjoined by more than one principle of statutory construction, it would be wrong to construe Section 14 in such a little way as to permit the prosecutor, however well-intentioned, to use it to evade the time bar applying to such prosecutions. The Crown had cut across Parliament's intention. The point being that where there are very specific statutory provisions, it would be wrong to use general provisions, and I think no matter how well-intentioned. Now, in terms of this case itself, the core of the analysis is at paragraph 248.
Sorry, in British Bankers?
Yeah, yes, sorry.
So
which
we're
is
staying
on,
in British
yes, on page 587. Sorry, just to look at how it was dealt with.
Right.
At 248, he says, I do not think that it is useful to ask and answer the question of what field is occupied by Section 404, and then ask whether the changes in the policy statement occupy it. That rather distracts from and misstates the issue of statutory construction. The question is whether or not the provision for a scheme in Section 404 carries with it the necessary implication that what the FSA had set out in the policy statement is excluded from the FSA's powers as a regulator. It is certainly not excluded by any express words. A specific provision is capable of carrying an implied exclusion of other general or other specific powers, but I do not consider that Section 404 implicitly excludes what the FSA has done, even though it would have been possible for a scheme to be set up to achieve much or rather more of the same end. And part of the reason why it was not was that it was cumbersome nature of the remedy and the fact that it would not apply to breaches of the principles. First, in construing regulatory provisions in an Act, it would require clear indications in the language that the greater the problem, the more Parliament intended to restrict the flexibility of the way in which the regulator dealt with it. Far more likely is that Parliament would have added to the regulator's armoury. There is no such indication here at all. Section 415A is a modest indication of the contrary. Although at 260 he accepted that the principle could be engaged, but just not in relation to these particular procedures, because
This was a case where policy was being used to supplement what was in the statute.
well,
But we're a million miles away from that, aren't we?
well, I think that the point is the FSA had a power to issue guidance, and that was being used to achieve something which could have been achieved under specific statutory provisions. And we are a million miles away from that, because effectively you had two regimes which were specific in terms of what they were doing.
I mean, we may be here adding to the regulator's armoury rather than...
Yes, well, I think one of the objections, which Mr. Justice Ousley said arose, was because it would be odd that the regulator had to use the specific statutory regime and that they couldn't deal with it in a more informal way. And so that was the point about it. It doesn't make sense that the more serious a breach, the less powers you have to engage with it. But here we say that what the revenue are trying to do here is precisely the same as what happens under Regulation 72 or 81. The outcome is precisely the same. It's not a situation where if you use one route, you get one outcome. If you use another route, you get a different outcome. The other case which I'd like to address, which is relied on by my learned friend, and I think also has been relied upon in the First Tier Tribunal in a case called Higgs, which I see has been added to the additional authorities, it is a case called Cusack, which is found at page 605 at tab 24 of the bundle. And this was a case in which there were two powers under the Housing Act to achieve an end. I think it was put up fencing. And one involved compensation to be paid, the other didn't. And the council used the one which didn't involve compensation. The Court of Appeal had applied the principle in Pretty and Solly that the specific excludes the general. But what we can see at paragraph 11 on 611.
Sorry, which paragraph?
11 on page 611.
Thank you.
That there was less reliance on that principle in the Supreme Court than below, and it was put more as a matter of purpose of construction. And the reason for that can be seen because the two sections had derived from different acts which had been brought together. I said that the principle wasn't engaged because and this is dealt with by, sort of most neatly summarised by Lord Neuberger, paragraph 61 on page 623. He said, although the principle expressed by Sir John Romilly, M.R., sometimes referred to by the Latin expression generalia specialibus non derogant, is a valuable canon of construction, I do not consider that it applies in relation to section 66 and section 80 of the Highways Act 1980. That is because I do not think that it is possible to treat section 66(2) as a specific provision in contrast with section 81 as a more general provision. They are, as Mr. Sylvain QC for the Council submitted, simply different provisions concerned with overlapping aims and with overlapping applications. I think the point which comes out of both those cases, is that where you have two, in a sense, specific regimes aimed at achieving different functions, then there's limited scope for the application of the principle. But that's not, we submit, what we have here. Because we have, both brought in by section 145 of the Finance Act 2003, item 4A, which deals with transfer of liability to a payee to be dealt with under the PAYE regulations, and subsection 7A, and both form part of a coherent PAYE code. And one is extremely general in its terms, and the other is very specific. And that does engage the principle. When you're looking at something as part of a single code and brought together in a coherent fashion by the same provision, it's very far away from what we're looking at in Cusack or even the Bankers Authority case. I should say, sort of just for completeness, that there is a point which pops up in the Rangers case where Lord Hodge goes through the tax legislation and goes, it's a patchwork which is brought together from different bits and for different reasons. And for that reason, you can't say that the fact that there has to be a payment to somebody in one situation excludes that there has to be a payment to somebody in another situation. That, of course, is because of the patchwork nature of the way the legislation came together. And equally, I say that doesn't apply here because the legislation came together in one section as part of one coherent code. So that's the sort of third basis on which we say the power doesn't extend this far. there is a specific regime to achieve what's wanted to be achieved, and it has to be used. So the last point on construction arises from the fact that the power in section 6847A is a power to permit a person, the payer, not to comply with PAYE regulations. And here the provision of the PAYE regulations, which it said they're not going to have to comply with, is the one which says you have to account for tax. But that obligation to account for tax is actually found in section 710 of ITPA, in subsection 4. And I think there is, you have to acknowledge, an interaction between that section and the PAYE regulations. So the section itself is on page 243.
And it says it's expressly subject to the PAYE regulations.
Subject to, in accordance with the PAYE
Yeah.
regulations, account to the commissioners.
Yeah.
Now, the question is, as a matter of construction, does relieving the end user of an obligation to comply with the PAYE regulations remove the obligation under section 710(4)? Well, in terms of accounting in accordance with the PAYE regulations, if they're not required to account in accordance with them, does that mean that there's no obligation? We'd submit not. But even if it can have that effect, it seems surprising that Hmrc can decide to supply collection mechanisms in order to remove an obligation to account in primary legislation in subsection 4. And what in fact is happening is that Hmrc aren't deciding that it would be inappropriate to comply with PAYE regulations. What they're deciding is that it would be inappropriate to comply with section 710 subsection 4. And that we say is not a proper exercise of the power.
Right?
So
What about the word subject to and in accordance with the PAYE regulations?
well,
If the PAYE regulations don't are
well, I think that's a point which we have to construe. What is it under the PAYE regulations which has been forgiven? It can't be the obligation to account for tax under section 710(4), because that's not in the PAYE.
It's the requirement to comply with the regulations. That's what the 7A expressly says.
Yes, but then the question is, what is it in the regulations that you're not being required to comply with? I think is really what it comes down to.
Right.
Bearing in mind that we're talking about subject to and in accordance with the PAYE regulations. And that says that tax will be paid at certain amounts of time. But if you're removing that aspect, put another way, how can Hmrc remove the obligation to account when that doesn't derive from the PAYE regulations? So they must be removing something else. And one has to then identify, well, what is that something else? And does that impact upon the obligation to account in section 710(4)?
Yeah.
And our submission is that no, it doesn't. It might mean that there's no practical way to meet that obligation, but the obligation remains. It's the obligation which is important in the context of regulations 185 and 188.
Is it relevant either way? The words we're now focusing on, subject to and in accordance with PAYE regulations, were themselves, I think, inserted by the Finance Act 2003, presumably at the same time as the section conferring the discretion which were, and the 7A were actually, well,
yes,
when you say the source of their power is to be found.
Yes, and at the same time as the section empowering the direction provisions.
Yes.
Which of course expressly deal with this point.
Yeah.
And see, I think if the directions regulations say that you don't have an obligation, that clearly is subject to the PAYE regulations because the PAYE regulations are taking priority. But if, and then what 7A allows you to do is say the PAYE regulations doesn't apply at all, it's not the PAYE regulations which are removing the liability. So you have to find some other basis for that.
I suppose I'm really wondering aloud whether we're going to get any help from looking at the Finance Act 2003 to see what was the package of measures that were introduced in that particular act, just to avoid any risk we're looking at any part of what was introduced into the code at that point.
My lord, we can certainly...
It's maybe a red herring. I'm just raising it up because...
I think what has happened is that we had provisions, obviously, in ITIPA, which was also brought in 2003.
Yes.
And then...
I suppose it might all have been just part of the fine-tuning to make ITIPA fit in with the rest of the code.
That's my understanding, but I will certainly go back and have another look to see.
Well, perhaps you can have a think about that, and if it is a red herring, by all means, just say so, and we won't waste time on it.
Will do, my lord. So, my lord, that's my point on section 710. It's a short point of construction. How does one make the discretion to remove compliance with PAYE regulations fit in with what's fairly clearly an obligation in the primary legislation? Before going on to whether the power was properly exercised, if I can just very, very briefly address the point on whether the PAYE regulations applied to the employers in any event. And the House of Lords considered the territorial scope of the PAYE regulations in the Clark and Oceanic case, which is at tab 7 of the authorities. And at page 122, we see the principle of construction set out. And the part of that principle of construction, just looking at the two extracts, broad, general, universal principle of English legislation, unless the contrary is expressly enacted or so plainly implied as to make it the duty of the English court to give effect to an English statute, is applicable only to English subjects, or to foreigners who, by coming into this country, whether for a long or short time, have made themselves during that time subject to English jurisdiction. And it's a question. Oh, sorry, I put this at page 122.
Yeah.
And we see in the second passage the same principle. All laws of the English Parliament must be territorial in the sense that they apply to and bind all subjects of the Crown who come within their fair interpretation of them, and also to aliens who come to this country and who during their time here do any act which on a fair interpretation of the statute as regards them comes within its provisions. If he is resident here temporarily and does an act which comes within the intent and purview of the statute, he as regards that statute, as does every alien who comes here in regard to all the laws of this realm, submits himself to the law and must be dealt with it accordingly. And the very short point is whether by registering for VAT, as they did, the employer...
Registering for VAT?
Sorry, registered for PAYE.
Right.
Apologies, it's... Okay. And therefore are subject to the obligations not only in relation to the tax on which they did pay PAYE, but also in relation to the other emoluments on which they didn't.
But by registering for PAYE, they were present and therefore...
Well, submitted themselves to the jurisdiction, to use the language from the extract. And that's the extent of the point. I'm not going to leave it any further.
So what are you... You're saying simply by registering for PAYE...
A person becomes subject to PAYE regulations applying that principle because they have submitted themselves to the jurisdiction. So, just moving on to the last point in relation to...
Before Millennium Friend does on, the risk of sounding procedurally pedantic, could Millennium Friend assist in whether he's advancing that point, which has not been taken so far, in the context of the claim for judicial review or an appeal from the upper tribunal?
Well, we're in the claim for judicial review, so I'm assuming it's in the claim for judicial review.
It is. It relates to a point which is made by Mr. McFarlane in his second witness statement, where he says they weren't within the scope of PAYE, and we simply don't accept that that's right as a matter of law. As I say, if the court takes the view that it's not something which we have permission to run, then that's fine, but we would say...
But you're running it in the judicial review?
Yes, well, in a sense, the points arise in both cases, because, as you'll have seen, we were arguing these very same arguments in the upper tribunal. But it's a pure point of law, in terms of the way we put it.
But you accept it's a new point which needs permission for you to run it?
Yes, I think I'd have to accept that, but... So the next point is sort of the argument that even if there was power, it was defectively exercised in any event. We now know that the decision was based on a policy. That policy is found at page 38 of the Judicial Review Bundle. And we can see that Hmrc say we will consider use of the discretion where contractors have used contractor loan schemes as an
Sorry,
option.
if you're going to take them to the policy, take them to the first page of the policy. Starts on page 8.
Certainly, the policy starts on page 5.
Page 37.
Sorry, page 37,
Yeah.
yes, sorry.
Yeah.
And you'll see there you get the background and why Hmrc say they would use it.
And sorry, whose guidance is this? I mean, this is issued by...
This is internal guidance issued by, I believe, the Contentious Issues Panel. There is a covering email starting on
That's
page
right. Oh,
35.
it's something called CIP, is that the
That's-
Contentious Issues Panel?
yes.
Thank you.
So it's guidance to HMRC officers.
Yes.
So it's a purely internal document, not one that was...
Yeah, yes, purely internal. And
Didn't get into the manuals or get published or anything like that.
no, there is an internal manual which is also included in Mr. McFarlane's witness statement,
Yeah.
which also deals with this policy. But certainly it hadn't been published. And I think that's partly influenced. As I was saying, it wasn't clear what the letter was saying when it was asking for information. When one looks at this, it becomes absolutely clear that what the test is and what the test being applied was. So you get the background and then why Hmrc would use it in Hmrc cases. But then in terms of the policy itself, page 38, when will we consider using 6847AB in contractor loan cases? We will consider the use of the discretion where the contractors have used contractor loan schemes with an offshore employer and where it is reasonable to assume the end user would not have been aware of or involved in the tax avoidance scheme. So that's the line they're setting. If the end user was aware of the scheme, then they won't exercise the discretion. And what that means in practice, and certainly now that this guidance is public, is that if a taxpayer can show that their employer knew what was happening, and query what means by their employer knew what was happening, doesn't mean their line manager, doesn't mean the board of directors, but if they can show that the employer knew what was happening, then the discretion won't be exercised and the tax won't be paid. So that's the line which has been drawn, and it places, I think, considerable importance on what the end user knew. And it has been identified by the contentious issue panels as the critical issue. What did the end user know?
Well, that's the criterion which will determine whether or not consideration will be given to the use of discretion. As I understand.
Well, we will consider it where it's reasonable to assume the end user would not have been aware of or involved in the tax avoidance case. So if we know that the end user was involved, did know of the tax avoidance, we will not consider its use. I think is my reading of that.
But I don't think it says that's the be-all and end-all.
Well, so sorry, we will consider the use of the discretion where contractors have used contractor loan schemes, yeah, fine, with an offshore employer and where it is reasonable to assume that the end user would not have been aware of or involved in the tax avoidance scheme. So if the end user was aware of, then I think it follows that they won't consider using it and you won't use it at all.
But if the end user wasn't aware, my Lord's point is that's not the be-all and end-all. They then have to consider whether on the facts of the particular case they should exercise the power.
Yes, I think that must be right.
And it sets out as a guide the following factors that might be relevant for reaching a decision on that point. But emphasizes just very near the bottom, however, the caseworker should look at all of the facts,
Yes.
and the above list is not intended to be exhaustive.
Yes.
Yeah, so it does look as though, as my Lord was saying, it's really a kind of, it's a threshold, isn't it?
Yes.
And then once that threshold is crossed, it's then very much put down to the caseworker to look at all the material and form a view one way or the other.
Yes, although I think sort of the way it has been adopted here was the threshold test was met.
Yes, and maybe in most cases that might actually...
And it's a contractor loan
a pretty
scheme.
strong steer.
Yeah.
Well, it says that the caseworker should look at all the facts, and the above list is not intended to be exhaustive.
Yes, although while saying that the caseworker should look at all the facts, I think it seems sort of quite reasonable in terms of the way it's setting this all out, that, well, did the employer know? When one then looks at, well, how do you go about finding out what the employer knew? You don't actually do very much. So the caseworker may use, so this is 1, 2, 3, 4, 5 paragraphs down. The caseworker may use 68478B, where it's reasonable to believe that the end user was not party to the scheme and did not know the contractor was using a scheme to avoid tax on payments arising from services carried out for the end user. To decide this, the caseworker should check the individual customer record to see what information we have on file or obtained through investigating use of the scheme. So it's very much consider that, but actually we'll just look at what we have.
And it does go on to consider the interrelationship with Regulation 80.
Yes, and it also makes the point over the page that if you haven't got enough information, the scheme should be investigated further under the rubric insufficient information about the scheme.
Yes, sorry, just to make the point about the 68478B and Regulation 80, with respect to that's nonsense. You can't issue a Regulation 80 determination against someone and at the same time say you don't have to comply with your PAYE obligations. It's impossible to have an alternative, because the point about the Regulation 80 determination is you have this obligation to pay. The point about the discretion is you don't have the obligation to pay. The two are mutually inconsistent. But what I think it does show is that this power wasn't being treated as a power to forgive the payer of an obligation. It's been treated as a power of fixing the payee with a liability. Because if you look at it in that way, then the alternatives make perfect sense. But if you look at it in terms of what Section 68478B actually says, that's a nonsense.
I think it says, doesn't it, that they're all that using both in relation to the same income would not be desirable.
Well, it wouldn't be possible.
Yeah, I think that's what it's saying. Well, it may not be saying that clearly enough, but it's saying you have to choose. At the bottom, at the top of page 40, when deciding, the avoidance should consider whether it is practical and appropriate to issue a Regulation 80 determination to the end user.
Makes sense.
Yes, but I think the point is you can't issue a Regulation 80 against somebody who you've forgiven of the obligation to pay.
It's when you're deciding whether to.
It's saying that they're all that you've got to choose between the two.
Well, I think you absolutely have to choose between the two.
Yes.
I think to the extent that it's suggesting that you can use them as an alternative, and certainly that was my reading, that makes no sense. You can't issue alternative assessments.
Well, it's talking about purely on a protective basis.
Well, even on a protective basis, I think where you have assessing powers, absolutely no doubt that you can issue 2 assessments on a protective basis. One person will be liable or the other. But Section 68478 isn't an assessing power. It's a relieving power.
Yeah.
And you can't assess the person and relieve them at the same time.
Was a possible preference is expressed in relation to Regulation 80 in case a court was subsequently to decide that 7A didn't bear the meaning that the reference was describing it.
If a court subsequently decides that actually you've forgiven the liability, that's very nice, but it doesn't have any impact on Regulation 185, absolutely, you can't then issue a Regulation 80 determination because you've already forgiven the liability.
Well, why can't you do so on a protective alternative basis? If there's going to be an issue about the validity of the exercise of the discretion, you don't want to get caught out again by missing a time limit. So
well, you might not want to get caught out again, but what I say is that's not a situation where you can issue an alternative, because it's not an alternative assessment. It's either you're saying that you have to pay or you don't have to pay. And you can't, at the same time, tell an employer that they both have to pay and don't have to pay.
I'm not sure you can. You can exercise a discretion, or at least purportedly exercise a discretion, but as a backup, you can say, in case I've got the exercise of my discretion wrong, now I'm going to make sure I don't lose out. I mean, the revenue don't lose out by omitting to issue a Regulation 80 assessment at the same time. And of course, one is put on the back burner until the validity of the exercise of the discretion has been sorted out. Anyway, at the moment, I can't see why that wouldn't be a possible way of proceeding, given as you yourself accept one can make alternative assessments, even though they can't ultimately coexist.
Yes, but this is the point. It's not an assessment. It's relieving somebody of liability.
Well, I know it's not, but why is it not mutatis mutandis, a situation where you can still proceed on an alternative basis at a very initial stage? I mean, maybe this doesn't matter. But
I don't think it's sort of directly in point here. Save that we say actually it shows that they're misapplying the power because they're treating it like a power to assess an employee where it's not. And the problem with the alternative analysis is that you're both deciding to forgive somebody a liability and at the same time deciding not to forgive them a liability. And conceptually, it's very difficult to see how that could happen.
So that's the policy.
Yes.
And then there are some illustrative examples.
Yes. And then
we've got both Mr. Finch and Mr. McFarlane explaining what they did in the particular cases.
Yeah, so for example, page 51, you have Mr. Finch setting out the relevant details. And you see at the bottom of that, he says that he's got no reason to believe that other people stayed behind Jones and Hoey is anything other than as agreed between Hmrc and their solicitors for the purpose, i.e. the common issues of fact and law. So there was a Rule 18 direction which basically binds lots of people in the tribunal, and there was a common issues of fact and law provided for that, and what he said is that well, I've got no reason to believe that doesn't apply because that's been agreed. And I don't think one can take a huge amount of objection to that because it was agreed that those were the arrangements.
Sorry, I missed. I was just being invited to agree something. I very rudely was turning around to ask for instructions on something. I missed what it was I was being asked to agree.
I don't think you're being asked to agree anything.
Okay. Phew.
But no, I was agreeing with Mr. McFarlane's approach to the common issues of fact and law, and saying that it seemed perfectly reasonable. Then, if we go to page, the manual, which I referred to, that starts on page 59.
Is the letter of the 13th of October 2017.
Sorry, it should be page 91. Sorry, my apologies.
Sorry, 91.
The number went round the side.
Yes.
So that's just the index to the manual, and then the manual. And just looking at the bottom paragraph, Hmrc has publicly stated that it expects employers and engagers to contract.
Sorry, where you took us to 91? Which?
Sorry, 92. Sorry,
92.
Page, so.
Right.
And just the very last paragraph.
Yep.
Hmrc has publicly stated that it expects employers and engagers of contractors to undertake reasonable due diligence to establish whether they have obligations under PAYE. However, contractor loan schemes are often complex and frequently interpose several layers between the offshore employer and end client, designed to disguise the nature of the arrangements. Where a contractor loan scheme is used, the nature and obligation of the scheme may therefore mean that the reasonable due diligence would be insufficient for the end client to identify an obligation to operate PAYE. And just make a point, there's a little bit of confusion as to where Hmrc have set the test. So we saw in the first published guidance that the relevant threshold was, did the employer know about the arrangements? Here it has been watered down somewhat to, did the employer know they ought to operate PAYE? There's some confusion, certainly, in Mr. McFarlane's witness statement, because at various times he's applying, did they know they ought to operate PAYE? And of course, if you've got arrangements which at that time were believed to work based on the decisions of the court, then nobody, not even the employers, would have thought they had to operate PAYE.
Well, if they were very well advised, they might have thought there was a risk.
Well, I think undoubtedly...
One of the problems is you have this enormous tax avoidance industry, many iterations and varieties of contractor loan schemes. And we're just dealing with one, but there were no doubt dozens of others, all different from each other. So, I mean, from the point of view of the collection authorities, it's a very difficult and fluid situation they have to confront. One has to read, I would have thought, the guidance and indeed the manual with that point very much in mind.
Well, yeah, I think if what's been accepted is that it's no excuse to say that you knew you didn't have to operate PAYE because you might have thought that these arrangements don't work, then I think that would be fine. But if you're setting the bar at, well, actually it would have been reasonable for all end users not to operate PAYE because the basis, the state of the law at the time, then they're never going to be caught by the exception. And there's a bit of a suggestion that, and we'll look at what Mr. McFarlane says on it, but I think there is a bit of suggestion that he may be taking the view that, well, given the way the law was, they wouldn't have known. In which case, if you've watered down the test from, are you aware of the arrangements, to, did you know you ought to have operated PAYE, and, well, actually, the law was uncertain, so you wouldn't have needed to operate PAYE, then this exception becomes meaningless, because it's never going to apply. And although you have something which looks like a reasonable basis for transferring liability, it becomes much less reasonable.
So, I'm really sorry, maybe it's the time, but I don't understand what, if any, public law complaint my learned friend is making now. There's certainly no pleaded complaint in the grounds, nor any articulated complaint in the skeleton, that the policy itself, the CIP guidance or the manual, is unlawful because it's internally inconsistent, and if so, how that helps the claimants. The only complaint about the manual is he says, well, one can infer that it took into account irrelevant considerations. We've dealt with that, and I'll deal with that in my submission. But if there's to be a separate public law complaint mounted about something internally inconsistent with the manual, then I'd like to understand what that public law complaint is. And if he's going to amend his grounds, ask permission to amend his grounds.
Well, issue 4 is about the formulation of the policy, but that relies on the duty of candour point that you have advanced, and you made the point earlier that it's about taking into account irrelevant considerations, and we should draw that inference. What is the current...
At the moment, I'm just taking the court through sort of what we have in terms of the guidance. I'm making some general points. I will relate them to what we say about the duty of Hmrc to have regard to what the end user knew, and bearing in mind the importance of what we say the end user knowing, and the importance which is apparently given to it in terms of the guidance as originally published. If that's watered down, then that's problematic in terms of giving proper consideration to that particular issue, which is very much something which is pleaded in our grounds.
You're not moving away from your pleaded grounds.
Not on this point, no. Just to note on page 95, we see the manual sets out both criteria. And I think this is relevant because it's referred to by Mr. McFarlane in the second witness statement. But so the third paragraph down, Hmrc does not need to know the identity of the end client to be able to use the power provided in 684(7)(a)(b, provided Hmrc has sufficient information about the way the scheme operates, so that it is reasonable to assume that the end client was unaware of and not complicit in the avoidance arrangement. So that's putting it in terms of unaware of. But then we see and then we see it again. Sorry. Hmrc will not generally use the discretion where Hmrc possesses evidence that either the end client was aware that the taxpayer was using an avoidance scheme with an offshore employer, or reasonable due diligence by the end client should have meant that they were aware that the taxpayer was using an avoidance scheme with an offshore employer. Which does, to a degree, beg the question of what reasonable due diligence requires. And we'd say more than just looking through. Well, what we'd say is reasonable due diligence requires more than just employing the employee and doing nothing. One would have thought that at the very least, reasonable due diligence when you're employing a contractor requires asking them, well, who is your employer? Something which everybody knew because they put it in their tax return. And are you getting any of your payment by way of loans? Those aren't difficult questions to ask. But the assumption is that they wouldn't have asked them.
If they are getting their employee via a UK-based agency or intermediary, I mean, is it realistic to suppose that questions of that kind would routinely have to be asked and answered?
Well, it depends.
Maybe in the modern world it is. But,
it depends what you mean by.
There's such a burden of regulatory compliance thrust upon people in every direction nowadays. You would hope that sometimes you can just take what you're offered at face value.
Well, I absolutely agree that there's a burden of regulatory compliance, which is a point I slightly made earlier on, and that one would expect that as part of that burden, you know who it is that is employing the people who are working in your business. And this is a point which actually comes up in the witness statement of Andrew Williamson, where he says he was employed to work on nuclear power plants. And so his employers absolutely made sure that they knew who was employing him and on what basis, because of the nature of their business.
Well, rather glad to hear
it. Yes, well, precisely.
In that particular context, but I mean, that's unusual.
Yes, but despite that, if you don't ask who the end user is, if you're Hmrc and you're just assuming that, then it does create something of an issue, and you're assuming a lack of knowledge, which in many cases may have been there. And I suppose the other point about this contractual chain is that if the employer is operating, or the end user is operating a preferred supplier list type arrangement where he has agencies A, B, C, and D who are asked to go out and find contractors to work for it, then it may be that these questions are asked of the agency and not necessarily of the employee. And the problem that creates is that if you only ever ask the employee and they've never had the direct contact with the end user, then the employee is never in a position to tell Hmrc, never in a position to show to Hmrc what the end user knew, because it's only, under Hmrc's approach, it's only if the employee himself personally gives that information to the employer that they'd be in a position to benefit from the guidance. Because in most cases, the employee won't have that information.
Well, where do you get that it's only if the employee gives the information?
Well, in terms of the way in which Hmrc go about the investigation, and this is sort of one of our complaints, is that it's very much focused on well, what has the employee told us?
Yeah.
The letter which was sent out, for
Yes.
example, was asking the employee, well, can you tell us what your employer knew?
Yeah.
And the problem for the employee is
That's
that
a start. If the employee provides information in response to that, no doubt that might or might not lead to further investigations. What's wrong with that?
if it did lead to further investigations, that would be one thing. But I don't believe that it did. And the ADU case...
There was no response.
Yes, in the ADU case which Hmrc rely on, there was a response that the employer had constructive notice. And apparently that wasn't good enough. And in fact, when I went to judicial review, Mrs. Justice Andrews was under the impression that actually what the employer knew was absolutely irrelevant. And so that was one of the reasons for refusing leave. Now, I'd say that given what we know now, plainly what the employer knew was really quite relevant. And in terms of candour, one of the points we make is that in the permission hearing for this case, reliance was placed on the ADU case. Had we been aware of what the policy was, we'd absolutely been making that point.
To be clear, am I right in understanding that then someone will be an end user even if they've just simply engaged a temporary employee for half a day or a day?
Yes, I believe so. And in the normal course of events, they would have the obligation to operate PAYE. And sort of going back to sort of the point about what reasonable due diligence is, bearing in mind that you have that obligation if you have an offshore employer, you would have thought it's fairly reasonable for most employers to identify that sort of fairly critical piece of information, because if they're engaging somebody with an offshore employer, they're being faced with a PAYE liability, which they have to comply with. So it's quite important to know whether your employee is employed within the UK or by somebody offshore. And so you would have thought that's a question which would have been asked in every case of a responsible employer.
Well, that may be right if the employer is a big financial institution, as it so happens they were in this case. But in many cases, one would think if there's nothing to put, if you're not somebody who follows the ins and outs of tax avoidance on a regular basis, why should one assume that an employee who you engage through a UK-based agency, totally above board and with nothing to no apparently suspicious circumstances, what should put you on inquiry that there might be tax avoidance behind it all?
Well, I think sort of a large part of it, certainly in terms of Mr. Hoey's case, and I think a lot of other people who've used these arrangements as dealt with in the Morse report, a lot of them, the reason why they're doing this is because employers refuse to contract with them directly. They say, you have to come through somebody else.
Yeah.
And so
Yes.
the employers are taking the benefit of not contracting directly, and they take sort of the various regulatory benefits which come with that.
But you don't need any offshore.
But
It's put into the scheme, put into the arrangements in order to deal with that problem.
yes, but what I say is, if the employer is taking the benefit of that, then one might expect the employer to be aware of the potential burdens and the potential downsides of contracting with somebody who's employed by somebody else, because if you contract with somebody who's employed by somebody else and that somebody else happens to be offshore, then you might find you end up...
But if you use Reed Employment Agency, why would you be on notice that,
Well, I think...
that there might be an offshore entity inserted into the arrangement somewhere, and there might be some payments into an EBT?
Well, I think if you're using Reed, you're using them to find you a contractor.
Well, I was just giving Reed as
Oh,
an
yes, that's right,
example
yeah.
of
Fine.
a
Yeah,
well-known agency.
Yeah, I think there are other agencies who are referred to within the first tier tribunal case. But they're providing you with a contractor. It doesn't necessarily mean that they're the employer of the contractor. And so I think one of the questions which you might ask is, right, you're not the employer of the contractor, who is? And that may have been asked in many cases. And if it was asked, that's something which the employer knew, but not something which the employee is in a position to prove that the employer knew. And of course, if Hmrc went along to the end users and went, what did you know about this? And they said nothing, we asked, but we were told that it was a UK-based employer, then in those terms, it'd be very difficult to complain, because actually they've asked the relevant question and they've got an answer, and it makes sense. But it's the closing your ears to what the potential answer might be, which is where we take issue, that actually nobody's gone along and asked the end user. And although they have asked the employees, it was in terms which could have been clearer, if I put it that way. And that's a point which is made in paragraph 97.
Sorry.
Page 97.
Sorry, it's page 97.
Yeah.
I have. I think this picks up what was in the guidance we looked at before, but looking at the paragraph with the 3 bullet points. As a guide, the following factors might be relevant in determining whether it's reasonable to conclude that the end client was not party to or aware of the tax avoidance. The existence of a UK intermediary independent of the agency or employer undertaking typical intermediary activities, e.g. payroll, support, invoicing functions, it is reasonable to consider, in the absence of evidence to the contrary, that the intermediary can only supply the end client with information relating to its functions and services that it provides. The intermediary is the person the end client typically has a contractual relationship with, and in consequence, one of the persons towards whom the due diligence inquiry should be directed. It may be reasonable to conclude on the evidence Hmrc has that the intermediary cannot pass to the end user any information on the arrangement as a whole, and this will impact on the effectiveness of the due diligence inquiries undertaken by the end client / intermediary. Now, the issue which we take with that is that it's basically assuming that nobody of any relevance knows anything. And while that might be a reasonable starting point, if you deliberately set up a scheme in a way in which you never ask the questions which might give you an answer, you start off with something which might look fairly reasonable in terms of, well, did the end user know? And actually what you realize is that you've got a policy where what the end user knew is largely irrelevant, except for in those relatively limited circumstances where the employee can prove that he's told the end user something. So that is the policy, as it were, and how it operates. The first point we make is that although that policy governs the decisions which have been made in this case, and it's fairly clear that both Mr. Finch and Mr. McFarlane were applying that policy when they exercised their discretion. We have been given no information as to the formulation of that policy.
Why do you need information about the formulation of the policy?
Well, because we say the formulation of the policy goes to why the decisions were made and why the things which were decided to be relevant were decided to be relevant, and the things which were decided not to be relevant were decided not to be relevant. And we don't know how those decisions were made.
But what point in the judicial review does that go to?
Well, that goes to the decision-making process adopted by Mr. Finch and Mr. McFarlane.
Well, you don't need to know how the policy was formulated to determine whether the exercise of a discretion against the background of the
Well, what we'd say is they were applying the policy. So if the policy was tainted by irrelevant considerations, then necessarily their decision would be tainted by irrelevant considerations.
So what are the irrelevant considerations that it's tainted by?
Well, we don't know because we haven't been given any disclosure. So it might be that when one looks at how the contentious issues panel went about this, it was all very proper, and they've considered everything very neatly, everything which is relevant, and that actually it shows that applying the policy, Mr. McFarlane and Mr. Finch were acting very properly, but we simply don't know that because Hmrc have refused to provide that information.
But I'm still at a loss to understand. If you have the policy and if you have the documents that reflect the exercise of the discretion against the background of that policy, that's the exercise of the discretion that you're challenging. What more I don't understand why you need something else.
Well, because the circumstances in which the discretion were exercised was that a policy was formulated with this particular exercise of discretion in mind. So in September, you formulate a policy. In October, you send off your letter. Or sorry, in September, you formulate a policy. 25th of September, you email Mr. McFarlane saying, this is what the policy is. Yeah. And then by the 17th of October, when he's done the work, you give your decision to Mr. Hoey. Yeah. So there was a process starting with the counter-avoidance panel, the contentious issues panel, whatever TAPS is, and get together and decide what are we going to do about applying section 6847A to contractor loan schemes. Right. And we've only seen half of the picture because we don't see any of the picture up until it's decided that we will apply the discretion unless you can show that the end user knew about these arrangements.
But there's no suggestion it's unlawful for a body like the Revenue to formulate policies to guide their staff in dealing with areas like this. So isn't this just, in old-fashioned terms, an unjustifiable fishing expedition to want to really go into all of the background of how the policy was formulated, just in case something crops up which you might be able to cling on to?
Well, with respect, my lord, no. It's directly relevant to the decision which is made because it feeds into it.
But it was a published policy, and so that surely that tells you what that tells you the criteria which are being applied, and you can test the evidence against that.
But how were those criteria adopted?
But what does it
Well,
matter?
so what? I mean, how? It doesn't matter, does it? I mean,
Well, I think it does matter if irrelevant considerations were taken into account.
But you've got no evidence that they were.
Yes, because the Revenue have refused to make any disclosure.
that's why it's a fishing expedition.
Well, I think if we weren't in judicial review, it's certainly something which we could apply for disclosure for. Because we're on judicial review, we're not in a position to do that.
You wouldn't be able to anyway. I mean, in a statutory appeal, it would be irrelevant.
I don't understand why it would be irrelevant because certainly.
You've got, as my lord has said, the published policy that shows you the criteria against which the decision was made, and you look at the decision and you examine it against the policy. What more do you need?
Well, that's if one accepts the policy. If one, for example, were challenging the policy.
Yes, then you'd be in jail.
Yes, well, I think this goes to jurisdiction points, which we can maybe deal with later. But the point is, we are in JR, and you don't have disclosure, but what you do have is a duty of candour, and which applies here, and the Revenue have decided not to provide this information. What they were asked for was minutes of the meeting of the CIP. They decided not to provide that. And that, we say, runs against the duty of candour. And what would be particularly interesting to know is what consideration was given to the fact that Hmrc were out of time to assess the end users. Why was it decided to adopt this policy rather than use the existing statutory powers? why was it decided that it's not appropriate to contact end users? And why was it that the knowledge of end users are really the only relevant considerations to be considered? Now, those are all very material questions. They weren't matters for Mr. Finch or Mr. McFarlane because those were decisions which were reached at the policy stage. And that's why we say it is relevant. And my learned friend refers to the sort of the three categories of relevant and irrelevant considerations set out in the Friends of the Earth case. Perhaps if we just look at those briefly, because it comes up later. That is Authorities 49, at page 1546.
Sorry, what was the page?
1546. Paragraph 116.
Paragraph 116.
Yes.
That's 1545, yeah.
Yes. You see, as it transpired, very little divided the parties under this ground. The basic legal approach is agreed, and a useful summation of the law was given by Lord Justice Simon Brown in Somerset County Council ex parte feuings, in which he identified three categories of consideration as follows. The judge speaks of a decision maker who fails to take into account all and only those considerations material to its task. It is important to bear in mind, however, that there are in fact three categories of consideration. First, those clearly, whether expressly or impliedly, identified by the statute as considerations to which regard must be had. Second, those clearly identified in the statute as considerations to which regard must not be had. And third, those which the decision maker may have regard to if in his judgment and discretion he thinks it right to do so.
So mandatory considerations, irrelevant considerations, and discretionary considerations.
Yes.
So how does that help us?
Well, just in terms of that's the authority my learned friend lies on in terms of what the relevance of considerations are. And in terms of those three categories, the difficulty is that in the absence of the information as to how the contentious issues panel reached the decision, we don't know sort of which ones did fall within category 3 but didn't make it into the guidance. And that guidance obviously was published with a potential judicial review in mind, which sort of isn't a bad thing, that public bodies are aware of court oversight, but it does mean that we've had a very sanitized version of what the decisions were. And we'd say that the scope and extent of the obligation to comply with PAYE regulations, and that obligation particularly in relation to the fact that a lot of these end users are out of time to be assessed, clearly falls within the first category as a relevant factor. But we have no reference to it. We have no idea why it was decided that actually you're going to forgive an end user of an obligation despite the fact that there is no enforceable obligation of that end user. And so if you're relieving someone of an obligation because it's inappropriate that they comply with it, you have to have regard to the extent of what that obligation was. And we don't know what regard was had there. Nothing to suggest that this was considered in terms of either Section 689 being in point or the use of the other regulations being in point. Other issues are that the identity of the end user is clearly identified as something which is relevant. But then you have the approach to finding out what the end user knew. And we don't know why that was adopted. In terms of the knowledge of the end user, we don't know why it was fixed in the way it was. We don't know why the approach was adopted, that it was reasonable to assume that the end user would not have been aware. What investigation took place in relation to that? Who was spoken to? Which industry experts? Or was this something which was simply assumed within Hmrc? Why was no consideration given to other potential sources of knowledge? Why are we only looking at what the employee could show? And we can't know what the actual position was because we've got no indications as to how the Contingency Issues Panel reached the decisions which they did.
Can I ask that, for my part, I'm struggling with the suggestion that whenever a public law decision is challenged and the public law body discloses policies, that there is a concomitant obligation as part of the duty of candour to disclose the process and discussions which gave rise to the policy. That, on the face of it, seems to me would impose a quite enormous burden on public bodies right across the spectrum. One can think of particular areas, to in every single case have to give full disclosure of all the discussions, presumably not limited to formal discussions, but informal discussions, of how they arrived at the policy, which ultimately is not you're not challenging the policy. You haven't at the moment said this policy is unlawful. Nor have you said this decision is not contrary to the policy, nor have you said the policy fetters the discretion in some way. You're just having a general, we want to look and see how you reach this policy, so we can decide whether or not the policy is unlawful or the decision is on the basis of considerations which should have been taken into account. And I have to say at the moment, I just find that very difficult, and particularly in the absence of any authority to support that approach.
Well, my lord, I think the point you make about clearly any challenge to a policy doesn't necessarily mean that you have to disclose
any challenge to decision.
Or any challenge to decision means that you have to disclose everything else. What makes this perhaps unusual and slightly different is that the policy was created with a view to making this decision.
But that's the case with every policy.
Well, not necessarily with specific decisions in mind. There was a specific taxpayer who had appealed to the tribunal, which was, well, two specific taxpayers.
But policies, by the very word, means this is something which is intended to be used in general and not specifically in relation to particular cases. It may be maybe those cases prompt the creation of the policy.
Yes, and clearly we do have a case here which prompted the creation of the policy. And what you have is the creation of the policy on the 22nd of September, the decision to sort of see how we can apply it, in his case, on the 25th of September. It's not that the two are unconnected.
So what?
Yeah, it's a facet of good administration. You do formulate policies to deal with like cases alike. So then you need to see what the policy is, and you need to make sure that it's not being applied in accordance with its terms in a way that's irrational or otherwise improper. I mean, you can do that once you know what the policy is.
Yes, but I think the issue which we had was clearly we weren't aware of the policy.
Well, now you are. We are where we are. It's very hard to understand why any of it matters once we've got the policy in the decision.
Well, because one of the issues one of the points we take issue for example, is that it seems ridiculous to be saying we're relieving an end user of an obligation to pay tax when actually Hmrc can't do anything about that obligation because they're way out of time to assess anything. Now,
why do you need to know to make that criticism? Why do you need to see the discussions behind it?
Well, I think the answer might be given that, well, in terms of Mr. McFarlane and Mr. Finch, that wasn't something which was relevant in terms of the policy. And what we'd like to know is, well, why was it decided that it wasn't relevant in terms of the policy? If it wasn't discussed at all, why not? Because it all goes to and all taints the decision which is made under the policy.
But if all they did was to apply the policy without considering other relevant considerations, you'd be entitled to say that they were fettered by the policy.
Well, yeah, my lord, I was very much more taking it in terms of that. Well, actually, the policy, the assumption being the policy had taken these points into consideration, which is why we wanted to see sort of what the basis of the policy was. My lord, you have my submissions on that point. I've given the reference to the DAS case in my skeleton argument and adverse inferences as a result of lack of candour. We say there's been a lack of candour here. There was no reason not to provide the information, and it should have been. And my lady, that takes me on to the next ground, which does go to the decision, and the failure to investigate. Just bearing in mind the time, I wonder if now is a good time to break.
Yes, I mean, just remind me where you are. What's the next point?
It's the ground identified at paragraph 38.3 of our grounds, and that Hmrc didn't properly investigate the knowledge of the end user.
Yes. And you're still, your timetable is still...
Yes, I think we should be
very good.
comfortable.
Right.
May I ask, are we going to be receiving
yes.
transcripts overnight?
I don't know, let me do it.
We are.
Thank you.
That's very helpful. Thank you
Hardly
very
so.
much. And just while we're talking about the transcriber, are you okay without breaks? We're conscious that you're not getting breaks. It is a long day. we did note that nobody had suggested breaks, but if you need breaks,
A very short break mid-session tomorrow.
tomorrow morning and in the
Much
afternoon.
appreciated,
Yeah.
Thank you.
Yeah.
I apologise, I should have raised that.
All right. Well, we could have raised it too. No? We'll do that. I'm sorry that you have had such a hard day. 10:30 tomorrow. Thank you.
All right.
Okay, yeah, if you don't mind.